even during eras of racial slavery, apart from our skin color, our hair texture could serve as a basis for our legal enslavement in this country. So what I've sought to do is not just simply overturn nearly 40 years of negative legal precedent by federal courts, but to try to overturn almost 400 years of racial discrimination on the basis of our hair texture.
The daughter of American civil rights activist, Professor Doris Wendy Greene, is a trailblazing anti-discrimination law scholar, teacher, and advocate who has devoted her professional life work to advancing racial, color, and gender equality in workplaces and beyond. Professor Wendy is celebrated for her pioneering scholar activism that combats grooming codes discrimination, and more specifically, the systemic discrimination African descendants suffer when donning natural hairstyles like afros, twists, braids, and locks. And she's also the author of the forthcoming book, #FreeTheHair, Locking Black Hair to Civil Rights Movements. Welcome, Professor Wendy Greene. How are you?
I'm well. Thank you so much for having me. It's so good to see you.
Absolutely, absolutely. So I want to start off the conversation by talking about the why, right? Why did you get involved in this work?
Well, as you mentioned, I am a child of civil rights activists, and in particular, combating racial segregation and other forms of racial discrimination in our society. So for me to be a civil rights advocate is very much a part of my blood. It's in my DNA. So I really could not resist that, that influence. But probably more recently, and I would say when I was in law school, what I came across was a legal wrong that I really felt, a legal injustice that I felt like I needed to make right, to correct. And in particular, as it relates to the ways in which federal courts have interpreted our federal civil rights laws, like Title VII of the 1964 Civil Rights Act. And in those cases where we see Black women overwhelmingly challenging grooming policies that ban natural hairstyles, what the courts would say is that it's unlawful race discrimination if you discriminate on the basis of an afro. But if you lock, braid, or twist that afro, then magically is no longer race discrimination, and therefore employers are free to regulate, to prohibit, to discriminate, and harass you even on the basis of natural hairstyles that are not afros. So seeing that, to me, just was nonsensical, but it also was a real racial injustice that was being created by the law that I wanted to correct. And so that happened over, now over 20 years ago, that seed that was planted in me over 20 years ago in law school. And then when I became, when I started to become an aspiring law professor, my initial research in my master's in law program at George Washington was to try to create a legal resolution to this problem, and to research about it, to write about it, and to advocate and educate about it.
Okay, and that you did, right?
Yes, that's what I've done. So yes, so for 15 years now, I have been devoted, my legal scholarship as well as teaching and broader activism has been devoted to dismantling, various forms of racial discrimination, but in particular, racial discrimination on the basis of natural hairstyles, because, this is a global phenomenon, and that African descendants, essentially since eras of racial slavery and colonization, we have been, our lives, not only our livelihoods, but our lives have often depended upon, the ways in which we wear our hair. In particular, I know we've talked about this before, but essentially, even during eras of racial slavery, we could, apart from our skin color, our hair texture could serve as a basis for our legal enslavement in this country. So what I've sought to do is not just try to overturn, or not simply overturn, nearly 40 years of negative legal precedent by federal courts, but to try to overturn almost 400 years of racial discrimination on the basis of our hair texture.
All right, you said a lot.
Yes.
There's so much in there. Like we can have a conversation just about that.
Right. Yeah,
because
absolutely.
What I want to pull out is the fact that you were in law school at the time and you came across the policies that inherently you said were wrong. So, and you said something else. You said that the law was creating the problem.
Yes.
Okay.
Yes.
How do we, I really want to hone in on that, because when I was thinking about hair discrimination and when the concept of hair discrimination and the law came about, happened in 2019, really for us is like, you know.
Right.
Not like law professor. I'm not a law professor, so
No. In terms of the legislation, yes.
Right, in terms of legislation, being the C.R.O.W.N. Act and also legal guidance that happened in New York City, which I'm going to get to in a second.
Yeah.
The concept was not something that I was just thinking about. Like, I understood the social implications of where, obviously, I started Main Moves Media because I wanted to have conversations around the fact that we have not been wearing our natural hair and we have been suffering a lot of consequences because of that, right?
Yes.
And this idea of a law, when it came out, people were like, wait, you need a law for that? There's a law that's going to not have people discriminate. So it was legal.
Yes, right.
Institutions to discriminate against us.
Right.
And so, I mean, that's just mind-boggling. About it, right? And so I know you have. And so that passion, that drive inside of you was to change this wrong into a right. And I commend you for that. I think that's amazing. You dedicated your whole life to this, like your life's work to this. So I don't want to just brush over that. That's not a light thing. That's a huge thing. And I remember our first conversation. First of all, I did all the research. I was like, who's this woman? I need to know who she is. And when I spoke to you, we were just having the most amazing conversation. I said, but wait, this is in your blood, like your father, like what he went through as a student in college and the sit-ins that he participated in and overturning his conviction. I was like, this is amazing. This is like a full circle moment.
Absolutely.
Talk a little bit about that and how that feels.
So, what you're saying to me, absolutely. I agree with you 100% about it being a full circle moment. And it's been a full circle moment for a lot of different reasons. And one of the reasons is the fact that, like we've talked about before, when I was young, when I was about 5 years old, I uncovered my father's role in the sit-ins in South Carolina, and the fact that he was arrested and was convicted for criminal trespass and had gone to jail, for his participation in the sit-ins. And that was really my first time even being aware of this system of Jim Crow and the fact that my parents had lived through it and were combating this system in various roles, but started when they were young. And for me, finding out that my father had gone to jail for doing what I thought was right, I was just incensed. and it was that sort of anger, that disappointment, that frustration, that confusion that really helped me to want to seek and better understand why is it that it appeared that African descendants were being framed and treated as the most inferior, or even coming up with this idea that we were. And then more broadly about race, who thought of this concept, right? And it's something that we often just don't even think about because we just feel like it's such a natural part of our being in our society. But there are social and political and legal actors that absolutely created this concept of race so that they could justify forms of racial exclusion and segregation and even slavery, right? So when fast forward, when we get the Crown Acts and this enforcement guidance from New York City, and to see my work actually playing an instrumental role in the development of the enforcement guidance, and with the Crown Acts, that a definition that I proposed in my very first article in 2007, Title VII, what's hair and other race-based characteristics got to do with it, to see that definition of race to be used in civil rights legislation, and in particular to try to dismantle this very systemic and pernicious form of racial discrimination. Last year, when California, actually it'll be last year, July 3rd, so we're in the week of celebrating this historic civil rights legislation. And I was in New Orleans at the time when the governor signed that law. And that's where I went to law school, in New Orleans. And that's where I went to undergrad at Xavier University in New Orleans. I went to law school at Tulane. And that's where the seed for me was not simply planted, but it had been cultivated in that space. So for the legislation, and something I had been advocating for at that time, nearly, almost 15 years, to happen in that place was really absolutely a full circle moment. And I mean, I get chills thinking about, the ways in which, you can see things divinely orchestrated, that I needed to be in those spaces in order for me to be in the space where I am today.
Absolutely. And I just thank you for your work and your service and your love, because that's what it is.
Yes.
Thank you. Something like this that you believe in, it's because you believe that there's something better. You believe in the truth. And
yes.
It's so important. It's so important.
And I want to say just really quickly, if you don't mind, and I say that even for those individuals who may sort of underestimate what you're talking about, especially because it may appear to be easy. It may appear that this thing has happened overnight. It has not. There have been legal scholars and other folks in just other disciplines in other fields. This is the beauty of the work. I meet so many people from so many different constituencies, from hairstylists to models to, who are all passionate and who have been passionate about this issue. So think about it. It's taken, in terms of really trying to combat at least the federal law and trying to cure the gap in federal civil rights protection as it relates to this, nearly 40 years. And I don't want to lose that, but also knowing that in trying to combat something that again, it's kind of nonsensical to even think that this should even be permissible. It's not easy, and you are confronted with a lot of naysayers, a lot of people who think like, why do you want to write about hair? Like that's so insignificant. I mean, even just yesterday, I saw someone, they were posting about their experiences with race-based natural hair discrimination and harassment in the workplace, and a poster or tweeter says, Black women, why do you always want to concern yourself with something so superficial?
They don't understand.
Right. They don't understand. But this is where I come in, right? And people who, like me, who come in to try to educate people so they can understand that this is not superficial. This is absolutely very significant. And it's very much related to not only to our freedom, and to our agency, to our well-being, emotionally, psychologically, physically, and physiologically. So it's huge. So I just wanted to just say that really quickly, that, I have had plenty of people to doubt and question even the legitimacy of my scholarship and when I set out to do it. But thankfully, I have a village of people who support and encourage and believe in the vision.
Thank goodness. I mean, I totally understand what you're saying. I've been in this space for a few years. And at first, people didn't get it. They were like, natural hair, talking about beauty, da da da. And my thing was like, no, this is so much deeper than hair. Hair, like you said, initially, fundamentally, it's about our freedom to be us. And in this country and around the world, we know that our freedom to be ourselves is something that we have been struggling for It seems like
Mhm.
it seems like forever. And so again, I just thank you for your dedication, your work, and everything. Let's go back a little bit because I wanted to talk about your first article that you wrote.
Mhm.
About the characteristics. I was listening to another interview that you did with another colleague, Dr. Afia,
Oh yeah.
and you mentioned something in that interview about race not being identified in a lot of anti-discrimination laws.
Mhm.
I was like, why? Why?
Yeah.
And I guess the question that I want to ask is the concept of race, right? You said
Mhm.
someone came up with it, right?
Mhm.
But it was never clearly defined when it came to discrimination. So how important was that for you to talk about hair discrimination equaling to race discrimination?
Sure. So exactly. In our civil rights legislation, pretty much across the board until more recently, you would not find definitions of race. And again, so that means the courts would be left to interpret the law and define it. Or, for example, administrative enforcement agencies like the Equal Employment Opportunity Commission or like the New York City Commission on Human Rights, those bodies might provide guidance to clarify what is it that we mean when we're talking about race discrimination. What kinds of forms? What does that consist of, right? So, with the federal civil rights jurisprudence, what was happening in these race-based discrimination challenges against grooming policies, whether it be natural hairstyles or sometimes it could be our dress, sometimes our names, too. We can think of lots of different, mutable characteristics that we're discriminated against because they're associated with Blackness. What you would see the courts do is they're charged with having to define what is race, and therefore what is the scope of protection as it relates to race discrimination. And what was going on was that they were misinterpreting the law or narrowly defining race as an immutable characteristic.
Okay, explain
Meaning,
what that means.
sure.
Yeah.
Sure. So an immutable characteristic in their minds was something that was biological, was something that was fixed, a characteristic that you were born with, or even a characteristic that only certain individuals who identified as Black would possess. And so when you think about that, something that you're born with, something that it cannot be changed or is very difficult to change, or a characteristic that only Black people possess. Well, to the latter, there is no characteristic that only Black people possess. There's not one. We think, Black people have brown skin, but we know that there are African descendants who do not, right? And so what has happened with how the judges were thinking about this, or at least I argue, is that they thought that afros was something that maybe only African descendant people possess, or to the extent that you have an afro, then that means you have some African ancestry. And that may sound pretty odd, but it actually, in light of how people racialize characteristics, it's not far-fetched, right? Even back to what I was talking about in terms of racial slavery, we had courts in the early 1800s that declared, no matter how fair-skinned you may be, no matter how much European ancestry you may have, the one thing that is always going to persist, the one characteristic that will always persist and signify your Blackness is your woolly hair texture, i.e. an afro, or something that looks like an afro. So fast forward, that is the same kind of concept that has been shaping federal judges' decisions, their interpretation, their definitions of race. So what we've done, or what advocates like myself, we've done in terms of this, is really trying to get, first for me, was to get the courts to rethink their understanding of race, to have a broader understanding of race, that characteristics that are changeable, like our hairstyles, like arguably even our skin color, like our dress, our names, our accents, those things have been racialized. They've been associated with particular racial groups. And in this instance, when we talk about natural hairstyles, it's been historically and even contemporarily associated with Blackness.
Yes.
So therefore, when we're discriminating on those grounds, more often than not, it is going to stem from ideas about race. And so it should be treated as race discrimination. So, yeah. So what I've argued in the piece was that when we define race, it should be defined more broadly in concert with how we racialize and how we discriminate on the basis of these mutable characteristics like hair texture.
And the idea of an afro, like where did they get this idea from? That just an afro means Blackness? Was that something that was argued and then they said, okay? Or was that something that they came up with and said, okay, well, this is it. Like if you have an afro, like that means that's a characteristic of Blackness. And this is the only thing that's
right. So, that's something I've been digging into to really try to see where did this argument come from. In terms of, at least historically speaking, the case that I'm mentioning deals with 3 women who were arguing that they were descendants of an indigenous woman by the name of Butterwood Nan, or at least someone who could be perceived as an indigenous woman. And at that time, in Virginia law, is that if you descended from an indigenous woman, you could not be enslaved. However, if you were descending from an African descendant woman, then you could be enslavable. And so they were charged or arguing that they were wrongfully enslaved by virtue of being descendants of an indigenous woman, and therefore they should be free. And so one of the things that the court did, and oftentimes people did, philosophers and pseudoscientists, jurists of that time, they looked at your physical appearance, right, to determine or try to determine what your ancestry was. And since freedom and slavery was based upon your ancestry, which presumably was being expressed through your physical appearance, what they did was they declared that these women were free because they had long, straight, black hair and a fair skin complexion. And so when they did that, they tried to demarcate what are the physical appearances that would base a presumption of freedom, and what are the physical appearances that would be associated with a presumption of enslavement. And in doing so, one of the things they said was, having a hair that was woolly or inclining thereto. Meaning that if you had a woolly hair texture or had the propensity of having a woolly hair texture, then presumably that meant that you had some kind of African ancestry. And therefore, despite your fair skin color, if you had a woolly hair texture, then you could be enslaved, right? And that idea very much still perpetuates in our thinking, right, about race and racial identity. We saw it during eras of racial apartheid, where literally, within lots of different communities, we still see it today, right, where if we're evaluating, we're assessing that hair texture. And if we see some curls or what we might call kinks, then the assumption might be that you have some type of African ancestry. And that has been a basis of segregation and exclusion in eras of racial apartheid and even today. And so I say that, so basically that concept, when we think about it through that lens, it sort of makes sense that a judge, right, when faced with having to determine what kinds of characteristics might signify Blackness, that they might just sort of naturally, or even somewhat logically, even though it's not, but logically presume that an afro is something that would constitute race discrimination, or discrimination on afro would constitute race discrimination. Now, the problem is that how is it that you don't see that if you braid, lock, or twist that afro, that that you don't, that it doesn't flow from that, right? And so that's where, I really my scholarship enters, is to say, if you can conceptualize that discrimination on the basis of an afro is race discrimination, then we absolutely need to further that thought. And therefore what flows from that afro should likewise, discrimination that's flowing from that afro should likewise be deemed race discrimination. So that's one part there. Another part too, when this case where we talk about the distinction between afros and braids, when that was decided in 1981, this is also during an era where we're seeing, so many people wearing afros as a form of racial pride. And in particular, pride as it relates to their African ancestry. And so I think too, that definitely shapes this understanding that wearing afros is connected to our African identity or our Black identity. And what the court said in that opinion was that, he boldly tried to insinuate that this woman who was challenging a policy banning braids, and she was saying that this was a form of race and gender discrimination to bar braids in the workplace. He insinuated that this had nothing to do with Blackness, her wearing braids, because Bo Derek at the time had recently worn braids in the movie 10. So since a white woman was wearing braids, that didn't have anything to do with Black women wearing braids or making it about Blackness. I think sort of, well, you didn't do it because this is something that was natural to you. You did it because you were mimicking this white woman. And again, that's a function of miseducation, right?
Hey, I almost thought my kid. Wait,
yeah.
We were mimicking the white woman, not the white woman was mimicking us.
Mimicking us, right. No, absolutely. And that's a running theme, right? In a lot of different spaces. Right. And so that's miseducation, right? So just because it appears that what I would probably suggest is that this is your first time, really even seeing, braids possibly. And then, again, this idea that we're appropriating a hairstyle from this white woman when we've been wearing braids for centuries. And so there's that lack of education or that miseducation, or arguably, this blindness to Black cultures and traditions that shape that opinion. So, there's a lot it's yeah. So you can see why I can write about this for days. I
know, and I can listen to it. That's just one case. And so this is my question. Like, when you read about this case, or the first article that you were reading about, that you were arguing, what was the response? Because I'm listening to you and it makes sense to me. It makes sense to me. But like you said, you've been working on this for 15 years. Like your career's been 15 years. So what has been the response that you've been getting when you argue that grooming policies that discriminate based on hair texture is actually race discrimination? Why did it take so long for people to get it? When you're explaining it in the way that you explain it, like, what were you getting a lot of pushback? What was your experience in that?
Yeah, I think there are a number of people who definitely did not think of it as race discrimination, and would often argue, especially in the workplace context, that this was more about employer prerogative and about, employers being able to create certain policies based upon their perceptions of what is professional and what's acceptable, and somehow they can separate that from race. Like, that has nothing to do with race. And I think part of that is because when we are saying that it's a form of racial discrimination, some people may take it as we're saying that you are being racist, right? And they don't necessarily want to identify with, say, for example, if you don't like those hairstyles or you have a bias against natural hairstyles and you can perceive yourself as being one who might try to regulate them. there's going to be an immediate sort of response to that, right? Like basically you're calling me a discriminator, and that's hard to accept. And that's regardless of what race you may identify as. That's hard for you to accept, that you might be perpetuating racism or a form of racism. And so so what happens sometimes is like you try to legitimize that kind of discrimination, because it's still discrimination. But so there's that part of it. You did also have people, I think when I have argued it through like really showing audiences the lineage of these grooming policies and the persistence of them, the ubiquitousness of them, not only in the United States, but I talk about this globally, talking about all of these different ways in which we're discriminating on these grounds. I think that's when people start to, the light bulb or the light switch kind of goes off, right? Like, oh, wow. That even if I don't, if I have a hard time thinking of it as race discrimination, I realize that this is wrong. And I realize the magnitude of the issue and the fact that our civil rights laws can and should actually attend to this issue. So we can attend to discrimination. So this is another argument. We can just attend to discrimination on the basis of afros, and we surely can attend to discrimination on the basis of discrimination flowing from the afro. There's no reason, really. Right? So there's that. So then I also talk about the consequences of this discrimination, and in particular, the harms, and that what I call the invisible harms of race-based discrimination. And a lot of people are not aware of, right? So they aren't aware of sometimes the historical linkages to this contemporary form of discrimination, and they're also not aware of the types of harms that this discrimination engenders. So what I have argued, as you know, is that when we are told that we cannot, especially as Black women and girls, told that we cannot wear our natural hairstyles, what you're basically telling us is that we have to meet a straight hair mandate or expectation. And what does that really look like for us? How do we achieve straightened hair? Well, many people don't know the processes, right? There are people who think that we're born, and some of us are just born with straight hair. They don't know that we spend hours upon hours straightening our hair. We use chemical relaxants, extreme heat styling, and what that has done, right? The damage to our psyche, the damage to our scalps, burning our scalps, burning our hair out. And also the relationship to these chemical relaxants to our physical well-being. In that there is research that has linked, long-term use of chemical relaxants potentially to higher risk or higher rates of uterine fibroids, uterine cancer, more aggressive forms of breast cancer, infertility. The list can go on, right? And so these are the types of things. So when you think about, as I say all the time, it's like if you say you care about Black women and girls' health, then you have to care about our hair. And when I have time to unpack all of this for an audience, by the end of the presentation, most people are like, yeah, free the hair.
And I'm so glad you said that, because when you were talking, I'm like, yes, that is why you are writing this book called Free the Hair, right? Because that's exactly what it is. You free your hair, you free your mind, you free your body, you free yourself to live into your full self. And so tell me a bit about the hashtag Free the Hair campaign. Is it Free the Hair Now campaign, or is it Free the
Well, so Free the Hair Now, I had to use that for social media purposes because Free the Hair was taken. But yeah, so and one, when we thought about using Free the Hair Now, is like, this is a demand like right now, and it will probably continue, right, until this discrimination is eliminated. I'm being aspirational here, but yeah, so hashtag Free the Hair really absolutely, it just signifies exactly what you're saying in terms of this being a critical part of our freedom, of our Black liberation struggle throughout the world, that this is so important and significant to our liberation, even especially thinking about it through that historical lens. right? And thinking about the ways in which our hair has served as a basis for either freedom or enslavement. So even today, and that's very much the case, right? So that we can be free from subjugation and subordination on this ground, similarly to our skin color. And so this is a critical part when we think about Black people's freedom around the world. And what also the Free the Hair campaign, I hope, is what I'm trying to do is increase public awareness around the systematic and global discrimination that we as African descendants suffer because of our natural hairstyles, a natural hair texture, and so that we can ultimately secure legal change, such as the C.R.O.W.N. Acts, such as, the enforcement guidance that we talked about from New York City Commission on Human Rights and other enforcement bodies, such as, policy change in our workplaces and our schools and other spaces, but even more personally or individually to bring about personal change, to try to dismantle the negative biases and stigmas that are associated with our natural hairstyles so that African descendants can freely rock our hair or freely wear our hair according to our personal needs and desires. And that's what the campaign has been about. That's what, the social media push for years, few years now, that it's, caught on internationally when people have been, talking about their experiences with natural hair discrimination or media conversations around natural hair discrimination. People have gravitated towards the hashtag. And it really came about from a little girl who's the daughter of one of my dear friends and law professor colleagues, when actually my hair was like yours at one time. And she saw a picture of us together from a conference, I believe. And she told her mom, she said, "Mom, I love her free hair." And so at that moment, when I heard that, it just resonated with me. And that's how Free the Hair was born, or at least the hashtag was born.
You know why that hit me? Because when I went natural 20 years ago, right? Mm-hmm. It's 20 years now. I used to get approached a lot from women who didn't really understand why I would go natural. They were curious. Mm-hmm.
Yeah.
I think a part of that was that they wanted a little bit of that freedom. They wanted their hair to be free as well. They just didn't think it was possible. Mm-hmm. Mm-hmm. What I mean? Mm-hmm. Possible. And I can't tell you how many times, we still have this conversation to this day about the very concern that women and men have about wearing their hair in its natural state at work. That was the number one complaint. Not a complaint. That was the number one concern of women who were interested in stopping relaxing their hair. Mm-hmm. Well, how am I going to be received at work?
Right.
I think that was really the underlying concern there, because some people would say, well, how would I wear it? There's a million ways you can wear your hair.
Right.
But the underlying thing was, how am I going to be received? Am I going to be received? Right. And I think that, when the C.R.O.W.N. Act and the legal guidance came out, that was one of the things that we wanted to address is natural hair professional. Because like you said, there was a lot of ideas around what is professional, and having to do with our hair, it never looked like this. It never looked like your hair with locks and braids and twists and cornrows. The way we wear our hair, just the way we wear our hair, because that's part of who we are. And so I think this is like a really fascinating time for me, because, like I said, I've been in the natural hair space for a long time. Diane Bailey, who's a natural hair stylist and educator and everything, and we've been putting on events and having conversations around really accepting. And so this is the other part, right? When you talked about changing these negative biases around hair, unfortunately, we had to do that work internally ourselves. Mm-hmm. Mm-hmm. So through this current natural hair movement, we have been encouraging, we have been having conversations around, and we've been educating women about the power that's really inside of us, right? Mm-hmm. Wear our hair in natural state and to get to know ourselves and get to know what our hair can do, because it can do so many amazing things. And now the law is kind of catching up with that, right?
Right.
We have been able to free our minds to a certain extent, but then we have the law now that we hit that ceiling, and now that's the next thing that needs to be obliterated, right?
Right.
Yeah. And so how close, how close do you think we are to that utopia, but that place where we can be free to be ourselves and wear our hair without any type of discrimination or any.
Okay, so I'm very hopeful about the extent of legislation and other types of legal interventions that will make it unlawful or clarify, really, that natural hair discrimination is a form of race discrimination. As you're probably aware, we have 7 states already that have passed the C.R.O.W.N. Act or a version of the C.R.O.W.N. Act, in California, which was the first, then New York, New Jersey, Virginia, Colorado, Washington State, and Maryland have all done it. And we also have had several municipalities in cities. And we've also mentioned even enforcement guidance, right, on the local as well as the national level to do so. So that's really exciting. And even more exciting, well, I will say more exciting, but equally as exciting, is the fact that we have a federal C.R.O.W.N. Act that was introduced in December of 2019. And I had the privilege of co-drafting the legislation there that was introduced by U.S. Representative Cedric Richmond and U.S. Senator Cory Booker. And for me, obviously, again, those full circle moments, right? Because I will have to tell you, I had been knocking on congresspersons' doors since about 2013 or 2014. I wrote letters to all of the Black members of Congress to try to amend our federal civil rights laws, in large part because of the negative legal precedent, but also at the time when we started to see the U.S. Army amending their grooming policies to get rid of those prohibitions against natural hairstyles. And what many Congress people and other legislators did not know was that permission, right? That ability to wear your hair freely, your natural hairstyles freely, that was something that was not the case, and still is not the case, for countless African descendant women and men in private workplaces, right? And they just were not aware. And even more recently, people were saying, oh, is that still a thing? I had no idea this is what was going on the federal level in terms of the federal court jurisprudence on this issue. So I say that to say is that, ultimately through the galvanizing of this legislation on the state level, the greater public awareness that has come about because of those really brave and courageous legislators and policymakers on the state and local levels, that then help to really, in addition to other actors, right? Because this is a collective effort of many people like yourself, like Diane Bailey, so many people who are involved, and so many Black women in particular that have been involved in this movement for legislative change. So I'm very hopeful about the fact that this will become, national or nationwide legislation in terms of actually reducing or ultimately eliminating the form of discrimination. This is, like other forms of discrimination, racial discrimination in particular as it relates to African descendants. Unfortunately, this is something that's been going on for centuries. And so for me, realistically, I know that it will likely take, possibly centuries to fully dismantle it, to where people may not have a clue about the negative stigmas and biases that are associated with it. And a big part of that is what we were talking about before, is liberating our minds, deconstructing those biases that often are rooted in very early childhood experiences, even rooted in experiences before we get out of the womb. And you've heard me talk about this before, before many of us are even out of the womb, people are already speculating about our hair texture, and therefore what that will mean, right, for our opportunities in life, how we're going to be received and treated in society. And that's really deep, that people are literally, some parents and grandparents are praying, right, that their child grandchild is born with straight hair, because they understand, unfortunately, that straight hair will likely afford you possibly greater opportunities, but also may also help you in terms of not having to be subjected to certain forms of stigma as you go throughout your life. That's huge. So that's something that, as you said, it's a personal mission and endeavor to have to really break that down within our families and within our personal communities, so that ultimately we're not, so ultimately at one point, maybe we will no longer have to think about that as a potential barrier for ourselves. So that's going to take some time. It's going to take really frank and truthful conversations, and it's going to take a change in not only our minds, but also our behaviors, and across the board in lots of different spaces. And that too takes time. So, but I'm still hopeful. I'm still hopeful about the fact that there will be change, and change actually happens over time. And I'm here for the long haul to see that change happen.
In addition to the law, it's really about educating people about these things, about what are the characteristics of race, or what, it's not just the fact that I have an afro, but the afro can then turn into something else. And, that should be protected as well. And so I want to know, in what form does that education come in? Is that when you're actually arguing the case, or does that come through your articles? Like, how do you educate people on the work that you do, as far as getting people to understand this concept of like hair discrimination equaling race discrimination?
Right. Well, for me, it's been a multi-pronged or multifaceted approach, I have to say. So obviously for me, the starting point was writing and publishing a series of articles on natural hair discrimination, and really dissecting it and keep advancing it. Hey, this is a form of race discrimination. It could be a form of intersectional discrimination, race and gender, or race, gender, and color. It's about race, gender, and class too. There's so many different elements to it, right? But, so the scholarship, writing about it, publishing about it, for me, educating lots of different constituencies. I will talk about this to elementary school age children, to octogenarians, like whoever will listen, I'm there, and as you know, I'll come to community events, I speak at conferences, I have traveled the world, literally, between India and Brazil, Cuba, the UK, educating people about this issue. In addition to that, reaching out to those who are in positions of power and authority, who can bring about not only legislative change, but other forms of policy change. So for me, the letter writing campaign from 2013, 14, like, I didn't know if anybody was going to listen, but I sent out letters to congresspersons to put it on their radar, hopefully to put it on their agenda if they're thinking about amending or making some clarifications to federal civil rights laws. When I was in their presence, I would talk about it, say, hey, by the way, did you know about this? And many didn't. It wasn't on their radar. To that point, when I have seen witness forms of this kind of discrimination affecting our children in particular, and other individuals in workplaces, I too have been involved in public letter writing campaigns, so that those administrative officials, those educational administrators, could understand that this was race discrimination and all of the impacts that we've talked about when they make these policies that regulate natural hairstyles. And I've also been involved in the litigation part of it, where I've served as an expert in cases, in particular right now as an expert in the case involving DeAndre Arnold and his cousin out of Texas, who was told that he could not graduate from his high school unless he cut off his locks. And that case is being brought by the NAACP Legal Defense Fund. And I've also co-drafted amicus briefs, which is a friend of the court brief. And the most recent case out of the 11th Circuit that still perpetuates this form of race discrimination in a case, again, challenging a ban against locks in workplaces. So really, but all that to say is that enforcement agencies like the New York City Commission on Human Rights, the EEOC, because of, even if they aren't able to see the presentations, they're drawn upon the legal scholarship to craft their legal arguments in the litigation, as well as in the enforcement guidance that has been promulgated by these enforcement agencies, these agencies that are charged with protecting our civil rights. And so I have to say the legal scholarship was really key and continues to be really key, because like I said, they may not be able to see me personally talk about this, but they can Google and find the scholarship. Yeah. And that's happened even on, I get letters from children who are middle school and high school because they're facing it in schools, or they know someone and they want to learn more about it. And when they're Googling, they come across my work. And I've gotten emails from them to say, hey, I'm doing this project for school. I want to educate my classmates about natural hair discrimination, and I'm using your work, or can you help me? And I've done it there too. So when I say it's a big thing in terms of trying to educate and agitate and advocate for change in so many different sectors. And that's what I've done for the past 15 years.
Oh my God, that's amazing. In this time right now where we are, and we're having a global conversation about race, right? After everything that's happened. How do you, and everything that's going on with the C.R.O.W.N Act, like you said, we're coming up on the 1-year anniversary of the C.R.O.W.N Act being enacted, being signed into law. How do you feel now about the chances of the Supreme Court's actually reviewing this case of Chastity Jones? And can you just give us a little bit of backstory on that? Yeah.
The EEOC versus Catastrophe Management Solutions case, which we just alluded to, is the 11th Circuit case that really helped to prompt the among other things, but it was one of the instrumental forces in getting this legislation introduced and ultimately passed throughout the various states, and also the pretty quick responses from local enforcement agencies like New York City Commission on Human Rights. And so that case involved an African-American woman who had interviewed for a customer service position job. She was qualified. She had actually been offered the job. And on her way out of the building, she stops by the HR manager's office, and they were discussing another matter. And during that conversation, the HR manager asked her, "Well, are those locks that you're wearing?" And she told her yes. And she says, "Well, I'm not going to be able to maintain the job offer, and as long as you have locks," and then insinuated that she would have to cut off her locks in order to maintain the job offer. Well, Chastity Jones, declined to do so. And to go back, the HR manager told her, I'm not saying that yours are, but they tend to get messy. You know what I mean? Right. So it's loaded right there, that her locks were not yet messy, but they had a propensity to become messy. So that's why.
Or we have to deal with all of that. Why don't you just cut them off before we even start?
Right. Got it. Right. And so, of course, I have problems with that. Absolutely. And that speaks to the types of biases, right? Is that, Black people's hair have, in some people's mind, has this unique propensity to be messy when everybody's hair has the propensity to be messy. So are you applying that standard to everyone? I doubt it, right? But that's my argument. So what the EEOC did, they took on this case, which was really quite phenomenal, because similarly, they were attempting to try to overturn that 1981 case that I was talking about, dealing with the braids analogy, they were trying to too overturn this legal precedent, almost 40 years worth of negative legal precedent on this issue. And in doing so, they used my legal scholarship to craft their arguments, as well as other legal scholars who are critical race theorists to address this issue as it relates to race and this limited understanding of race that had been applied in these cases, to really get them to understand how natural hair discrimination can constitute race discrimination, and then more broadly thinking about the consequences of this discrimination, right? So that case ultimately, unfortunately, the 11th Circuit fortified, even further perpetuated this state of affairs that employers have a legal right to discriminate on the basis of natural hairstyles that are not afros. And they even went on to make this distinction between afros and braids. And afros, in this court's mind, was that they're a hair texture, whereas braids were a hairstyle. So if you had this hair texture and you were discriminated against on the basis of the hair texture, i.e. afros, then that's race discrimination. But since, braids and locks and twists are mutable or changeable characteristics, they considered those to be hairstyles. And those were cultural characteristics. And Title VII does not prohibit discrimination on the basis of culture. So therefore, discrimination on the basis of locks will not violate our federal civil rights laws. So that was the reasoning behind it. Wow. So essentially with that case, and again, that was a case that I was engaged in and involved in terms of the scholarship being used, but also, again, intervening on behalf of Chastity Jones with the NAACP Legal Defense Fund, Dean Angela Awachi-Willig, who's at Boston, to draft an amicus brief to support the EEOC's argument that this is race discrimination and that she should be able to proceed in a federal court of law to challenge this grooming policy. Unfortunately, the 11th Circuit did not agree with us. And that then the NAACP Legal Defense Fund did try they filed a petition with the Supreme Court. And unfortunately, or maybe fortunately, depending on how you look at it, the Supreme Court did not agree to review the case. So what was going to have to happen is that we're going to have another case. Another case that would challenge, a natural hair discrimination or natural hair ban. And it doesn't have to be workplaces, but a natural hair ban. And so just waiting for the right case to do so.
Would it be the case? That wouldn't be a case?
No, it would not. No, yeah, we're outside of, once they say that they're not going to review it, it's done. The case is dismissed. So that 11th Circuit opinion, right? That 11th Circuit opinion still is the law.
Now, law in that state, or is that law period?
Yeah, so that's a good question. So it's the law for that circuit, which is Alabama, Louisiana, and is it right? No, I'm sorry. Louisiana's the 5th Circuit. So it's Alabama, Georgia, and Florida. So what that means is that, you could have other circuits, there are other federal circuits that can decide this issue and decide it differently than the 11th Circuit, which we are hoping for, right? That you file this in another jurisdiction and then ultimately you may have a different kind of decision. And I think what's been happening at this moment with the legislation throughout the states, as well as the federal bill being introduced, and just greater levels of awareness around this issue, will absolutely help to positively shape a different outcome if this is filed in another jurisdiction. Also, one thing that a lot of people don't know about is that, and not to get too much into the weeds of things, but now there is a dissenting opinion out of the 11th Circuit. So this case had been reviewed a couple of times. And so the last time it was reviewed, a dissenting opinion came from this. So to my knowledge, what that means is that you have 3 justices who did not agree with the other judges. And they actually did see how this ban against locks can be a form of race discrimination. So if it were left up to those 3 judges, Ms. Jones could have proceeded, right? And therefore it would have been interpreted that natural hair discrimination could potentially violate our federal civil rights laws like Title VII. So we have 3 justices. And that is really huge because to my knowledge, this is the first time where we saw 3 federal judges actually sign off an opinion. Though it's a dissenting opinion, it's not the rule of law. But I think that also signals, a hope in terms of the legal change that can happen if we get another case. And just to kind of, I guess, in that opinion too, the court or those 3 judges look to some of my work in that case again. And what they argued, which I've argued, is that this doctrine, what is known as the Immutability Doctrine, that has been the basis of this demarcation between Afros as an immutable racial characteristic and anything that flows from the Afro as a mutable cultural characteristic, that Immutability Doctrine, that too I've been trying to dismantle through my work.
Yes.
They said that was a fiction. And I too have argued that that is a legal fiction that needs to be eliminated from our federal civil rights jurisprudence. So that's pretty, that's something that a lot of people don't talk about, probably don't even know, that we do at least have 3 judges who are on the right side of history here. And I think there will be more.
So what I'm learning in this conversation also is that, like you said, change takes time. But doing the work is so important, because all of the time that you have been fighting and been writing and been educating, like now this time is here, right? The time is here, and the work has been used and it's been instrumental in creating all of this legislation that we're seeing now. And so for all of the legal students, the students who are in law school right now, like, know that your work is important. Your work is important. Yes, absolutely.
Yes. Well, your voice is important. Your perspective is important. And I think that's so important for people to know and to be reinforced. And it does take time, and every little bit counts. It's like you're chipping away at it step by step. And so it's something I actually just mentioned to some of my law students just maybe about a week or so ago, because I understand their frustration. I understand that they're looking at things that are going on in the world and saying, how in the world can we play a role in change, in positive change? And sometimes can get disheartened by the fact that it seems like things will just never change. But what I know for sure, it is going to take time, but I know that if you are very committed, that you can make changes in so many different ways. It may not always result in exactly how you would like it, but absolutely you can make positive change and do so in some of the smallest but yet instrumental ways. And that's one of the things that continues to keep me going, even in times when it seems that that there may not be, and that these problems are just so much bigger than what you feel like you can personally address. But it's not only about individual change, but also to that point about the fact that it's going to take a collective action. We can't do it by ourselves. And that I know to be true. I've done a lot, but I cannot do the work. The efforts that have been actualized could not happen without the work of those that came before me and those who are surrounding me and advocating in their own ways. So that too is not lost on me.
Professor Wendy Greene, I thank you.
Thank you. Well, I thank you for everything that you do. I absolutely do. Again, this is a collective effort. the work that we do is mutually reinforcing. We cannot get it done without having folks who are in these in these spaces, who are committed to these struggles, and committed in a very genuine and authentic way. And I really appreciate you for being one of those people.
Thank you so much. Yay!